as of a couple days ago. Next. The lake water is saline. It currently is somewhere between 2 and 2.5 times the salinity of seawater. When we get to the lake level stabilization that is provided for in D1631, we will be at about 2 times the salinity of the ocean. It's important to understand that the salinity of the lake goes up when the lake level goes down. So the lower the lake gets, the worse it is for the brine fly and brine shrimp. Next. 82 was the year that the lands managed by the state were designated, the relicted lands primarily, were designated as the Mono Lake Tufa State Reserve. Remember I told you everybody loves the pictures of the tufa, right? Next. This is the cornerstone, if you will, of the ecosystem. Brine fly and brine shrimp. Why? Because the birds live off of them. They are unique species to the Mono Basin. The productivity of these populations of species is unbelievable. Hence, the remarkable number of birds that historically lived in the basin. Next. 300 bird species. About 11% of the snowy plovers that the mating pairs in the state are there. There's only about 1,500 mating pairs around the state of California. I can tell you that because I was at a Coastal Commission hearing last week where they announced that was the most recent count. The brine fly and brine shrimp are their primary prey, and we also have a huge number of a variety of other bird species as well, including gulls, eared gribs, Wilson's phalaropes, redneck phalaropes, and a boatload more. Not so many ducks anymore, however. There's been a significant decline in the duck population, which at one time was over 500,000 annually. Next. Thank you. In 1990, the Mono Lake was made part of the Western Hemisphere Shorebird Reserve Network. Why is that important to me? I'm from Monterey County. And there's a boatload of California gulls that come over to the east side of the Sierras and nest. And if you come to Monterey, or you come to Pebble Beach, or you come to Carmel, you can see them summering where I live, as opposed to, well, actually they winter where I live, and they summer over on the east side. And so that's why when I first got appointed to be the hearing officer, there was something a little warm and fuzzy for me in terms of where I had grown up. Those of you that don't, how much time do I have left? You have 7. 7, good. Okay. For those of you that don't know much about my background, I was on the Monterey County Board of Supervisors, and before I got here, I had been responsible for drafting a number of local coastal plans and helping to establish the Monterey Bay National Marine Sanctuary and the Elkhorn Slough. My relationship with the Eastern Sierra was pretty thin, and most everybody who's here in the audience who knows me knows that was the circumstance. But one of the things I did happen to know about was I knew about air quality, because for 12 years I'd been the chair of the Monterey Bay Unified Air Pollution Control District. And so when they started talking about PM10, particulate matter smaller than 10 microns, and why that was a massive air pollution problem on the east side of the basin, I actually knew what they were talking about, contrary to some other hearing officers who have sat on the State Water Board. And why is that significant? Because the last 2 feet of elevation were a consequence of that. And I will tell you a story now. One of my dearest friends during the course of my life was a guy named John Brown, who I knew long before I got on the State Water Board and who subsequently was appointed to the State Water Board from Southern California. John Brown had worked in Orange County, the Orange County Water District, for years and years and years. John Brown, when I was the hearing officer for Mono Lake, was taken by Jim Canaday and some of our staff over to the east side. And they got there on a day when winds were blowing at 90 miles an hour. He came back and walked into my office in the old Bonderson building, and he said, I just got back from Mono Lake. I said, what'd you think? He said, man, you got to do something about that air pollution problem. I said, what? He says, I got over there, and there were railroad ties flying through the air. And apparently, I subsequently discovered from some of the folks who had attended that field trip with him that wind gusts had gotten up to 100 miles an hour that one day. And so it was absolutely the worst air pollution problem you could have possibly imagined, let alone personally seen, in that one day that he happened to arrive. So remember I told you sometimes better to be lucky than smart? We got 2 extra feet on the level of the lake because John Brown wanted to make sure that the east side had enough water covering it so that the PM10 problem was at least largely addressed. Okay? 4 minutes, no problem. The next. The Mono Basin streams were dry. Next. In 1984, the Mono Basin was designated as a National Forest Scenic Area, which was one more layer, if you will. It was one more pancake in the stack of protections that provided for the ultimate preservation that was recognized and addressed in 1631. Next. The Audubon decision, Hap talked about it. We don't need to go into it. Most of you that are here, unless you got lost coming into the building, have read the Audubon decision and know what it says. We were responsible for addressing that within the context of the decision. When the Supreme Court handed down the Audubon decision, I was a brand new, well, I was a junior county supervisor in Monterey County, and I can assure you no one at the State Water Resources Control Board, including Andy Sawyer, who's sitting right over there, who was at the state board in that time, anticipated me being the hearing officer 10 years later. Next. No, I'm sorry, back one, please. There. This is Justice Broussard. I put his picture in here because we all owe him a great debt. He was not recognized at the time when this decision was handed down. And in fact, this was probably the last great decision of his career. And we, the entirety of the population of this state, owe him an unbelievable debt. Next, please. The cow trout decisions were addressed, and we've got someone who's far more adept at talking about those 2 decisions than I am, who's going to be here in just a minute. I comment on those because they were the lead into D 1631. 1631 lasted for 43 days. We had 125 witnesses, over 1,000 evidentiary exhibits, 14 parties participated. I was the hearing officer for all 43 days. And when everybody else went out to have lunch, I was the hearing officer for all 43 days. And when they all went home for dinner, I was still the hearing officer for all 43 days. And for those of you that don't understand what that means, because Bruce Collins is sitting here with a big grin on his face, it wasn't 43 days. It was 43 days and nights. Because if it hadn't been nights, we'd still be sitting there hearing testimony. So, long and the short of it is, there's a picture of the 5 members of the state board who unanimously adopted D 1631 on September 28th, 1994. They photoshopped some guy with hair on the right-hand side. I don't know who that is. That's where I was sitting, but I can't tell who that is anymore. 1631 amended the water rights requirements of the licenses of Los Angeles. It set in-stream flows. It prohibited export of water from the basin until after the level reached 6377. And in fact, and we hopefully we'll talk about it a little bit, there are provisions in 1631 that address the current drought that we've got. We anticipated periods of drought, and so there are mechanisms in the decision that we had anticipated to kick in as a result of droughts like what we're currently experiencing. Got it. As part of the decision, we established Mono Lake as an outstanding national resource water, and we did that in order to advance the level of protection. And rather than go on, ladies and gentlemen, We've got at least one more person on this panel, and then hopefully we'll have an interesting discussion about where we see the public trust doctrine going before we leave today. Thank you so much.
We'll go on to third speaker, and then there'll be a little bit of time for questions. David Cobb works now for HRR Incorporated. At the time, he was an aide to Mayor Riordan during the negotiations surrounding the Mono Basin cases. Thank you, David.
Thank you for the, I'm going to sort of try to step aside. Can we bring up the slide, please? So how many people in the room are lawyers? Yeah. How many of you are studying to be lawyers? A few in the room. So I'm going to offer the non-lawyer perspective today. And I'm a political guy. I'm a political person. I've spent 32, can you hear me okay? I've been doing politics and policy for over 34 years now, and at the time of my involvement in the Mono Lake decision, he's trying to find it. At the time of my involvement in the Mono Lake issue, it had already been going on for almost 20 years. And it's hard today to look back and think it was 20 years ago that we started working on this project, myself and Martha Davis. And what I'm going to talk to you a little bit about today is the human element, the human dynamic between solving water policy issues. And we're still looking. There we go. So this is a little rubric that I put together for a presentation I made to the Latino leaders working in water recently. I had just graduated from the Harvard University at the John F. Kennedy School of Government. I'd come back to Los Angeles where I had grown up. I worked for a short period of time at the City of Los Angeles in what's called the Chief Legislative Analyst's Office. And when I worked at the Chief Legislative Analyst's Office, one of my responsibilities was the Metropolitan Water District of California. Now, some of you may be aware of MET. It certainly is the 100-pound gorilla in water politics and water policy in Southern California. And I just want to give you a sense of where things were at that time. My first trip to the Metropolitan Water District was when it was on Holy Hill. We call it Holy Hill. It's now a church right there off of Sunset. There was literally, and I am not making this up, an ambulance, nurses, and oxygen bottles at the Metropolitan Water District meetings at that period in time. The guys who were on the Met were so old, several of them had to be wheeled in wheelchairs. They had to have nurses there, and they had to have oxygen bottles. And I'm not making this up. This is absolutely the truth. This is probably 1992, 1993. There were very few Latinos, African Americans. In fact, there were almost no Latino. There were no Latinos, no African Americans, no Asians, and there was one woman who served on the Met at that time, and she was the wife of a very prominent water attorney in Southern California, and that was how she came by her position. And I just want to give you, so this is some background on where the water world was in 1992. When we think about water policy making, water policy decisions, I always say that water follows the path of least resistance. And when you're trying to come to a conclusion, when you're trying to make water policy, always keep that in the back of your mind. Water follows the path of least resistance. And we'll come back to that in a moment. So in thinking about water policy issues, there's the politics, the human dynamics to it. I'm going to talk a little bit more about that. There are the market forces and economics. And too often, attorneys in particular get hung up in the legal issues. And they don't take enough time to understand the market forces and the economics involved in water policy decision making. So if you're working in water policy, it's very important for you to understand the cost of water, how water operates, who water is bought and sold by, what are the market dynamics that play in water policy decisions, what are the economics that play in water policy decisions, governance. Now, this is another thing that attorneys in particular don't pay enough attention to when you're trying to solve water policy issues. What is the governance structure of the parties who are involved in the matter or the issue? So in this case, there was the governance of LADWP. There was the governance of the City of Los Angeles, the City Council. There was a governance of the Mayor's Office. There was a governance of the State Water Control Board. I'm getting it wrong. Felicia's looking at me. So the governance matters, because you can't come to a conclusion in a water policy matter unless you're able to bring the governance of the various bodies together. It's not just a matter of fighting it out in court. It's not a matter of fighting it out before a hearing officer. You have to understand what the governance mechanisms are the agencies that are involved in the final decision. And then finally, the environment. And that was certainly a major factor in at least my thinking as I became involved in this issue. Now, the other things that are very important when you're looking at water policy, the history. And you can't really talk about the Mono Lake Basin without talking about the history of Mono Lake, and you've heard a little bit about that today. Very important to understand the history. The geography. Again, attorneys want to focus on this decision, that decision. It was very important in understanding the geography of Mono Basin, the 5 streams that fed into it, which ones LADWP had the right to take water out of, how much water, where they came into the lake. Those were all very important factors. So the geography, the geology. Now there's 2 kinds of geology. There's the geology of the location, right? What is the geography like? What is the geology like? And this is particularly important when you're dealing with groundwater basins. And many of you who are here today who are involved in water, with the passage of certain legislation last session, I can tell you that you will be involved in groundwater discussions for the next 20 to 25 years. So if you're going to work in groundwater, you have to understand the geology. It's very important. Now, there's another kind of geology as well. I call that the historic geology, the depositional geology. And what do I mean by that? This goes back to the politics and the human dynamics element. In every major water policy discussion in California today, there is the history, but there is the depositional geology. And what I mean by that is the layers of personal interactions which have gone on before your involvement. You can't just look at water policy in an isolated legal fashion. You have to understand the history, the geology, the people involved, the depositional geography. And by that I mean all of the human interactions that have gone on before. Because very often when you're trying to solve something in water policy, it really goes back to the human element. These 2 guys don't get along. But if you don't understand that those 2 guys don't get along, or that they had a history going back 15 or 20 years, and you step into it, it's going to be very hard for you to maneuver in such a way that you're able to produce a solution. And then finally, in today's world, and again, this is something attorneys do not understand enough about, we make decisions based on computer modeling. Now, all models are useful, but all models are also wrong. And as we engage in policy making in the water resources world, we have to understand that models are approximations of reality, but they are not reality in themselves. And that's something as attorneys and policymakers we need to really continue to understand. So that's my rubric, my way of looking at water policy decisions, and I want to talk about the politics and the human dynamics for just a moment. So I was a fairly young person. I was about 32 years old. I graduated from Harvard. I'd been to USC. I thought I was a hot shot. Somehow I was tapped by Mayor Reardon to join his administration. And the Reardon administration was very odd. If you wanted to work for them, then you couldn't work for them. They had to pick you. And that's how Mayor Reardon really operated. And for some reason, I was picked. When I came on, I was assistant deputy mayor for city services. I had the airport, the harbor, the Department of Water and Power, the Board of Public Works, and the Metropolitan Water District were among my portfolios. And one day, sitting at my desk, a letter came across my desk. And the letter was from a gentleman named Ed Manning, who was serving at that time as the president of the Mono Lake Committee Board of Directors. And I don't think Ed is here today, but I know he was invited. There was a letter from Ed Manning, and I read this letter. I remember sitting at my desk, and I thought, this is an interesting letter. It's an interesting problem. It's an interesting challenge. And at that time, for those of you who lived in Los Angeles, particularly on the west side, it was not at all unusual to drive around the west side and see 2 or 3 Save Mono Lake bumper stickers on cars every day. This was really an issue that motivated west side voters who were more liberal. They didn't call themselves progressives at that point in time. They were liberals, and who were concerned about the environment. Now, Mayor Reardon had been elected just after the riots. He had run as a Republican who was tough enough to turn LA around, but he also had made significant inroads into the traditional Democratic constituencies. After he was elected, he had a big outreach to the gay and lesbian community where he rode in the parade. He put a gay man on the police commission. He appointed many gays and lesbians to his staff and also to commissions. And this was something that was very unusual. Mike Wu had Mayor Reardon used to say that he was the only mayor who implemented his opponent's promise. And that was Mike Wu had promised to put a gay person on the police commission. So the mayor had made a lot of inroads into the gay and lesbian community. So when this letter came across my desk about Mono Lake, I thought, this is fascinating. What if we used this as a way for the mayor to begin outreach into the environmentalist community in Los Angeles? And so I picked up the phone and I called Ed Manning. I didn't know who he was. I didn't know anything except that I had this letter from him. And I asked him about the letter, if he could tell me about it and a little bit about the issues, and if he would come in and see me. And so that was really the beginning. It was a letter that Ed Manning had written to the mayor that came across my desk, that sparked my interest, that caused me to pick up the phone and call Ed Manning and say, let's talk about this. And my interest was in trying to have outreach on behalf of the mayor into the environmentalist community. From that initial letter and that phone call, we were able to arrange for the mayor to speak at a very prominent environmentalist event, which is occurring. I think it was being put on by Hilda Bay at that time. We became deeply involved in the issue from the mayor's office. I remember flying in a helicopter along the aqueduct all the way up into Mono Basin. We met Martha Davis and Ed Manning and Jerry Giwi from the LA Department of Water and Power. There's a name that doesn't get enough credit in all of this, Jerry Giwi, who really is the person who, at LADWP, against his better judgment, against everything that was his career. And what you have to understand about Jerry is, in the old days, you did not rise to the head of the water department at LADWP unless you had done your turn in the Owens Valley. You could not become the head of the water department if you hadn't spent your time in the Owens Valley. And Jerry Giwi was really the last one who had done his time in the Owens Valley. He had this emotional connection to it. He knew it better than anyone. And he really did not want to do this. He deserves a lot of credit. We met at a place called the Cane Ranch. And I remember that day because we joked that from there they would call this the Cane Ranch Agreement or the Cane Ranch Accords. And really at that point, I think that trip helped solidify a level of trust among all of us that we could move forward and somehow try to come to some conclusion about Mono Lake. The city was spending tens and tens and tens of millions of dollars on litigation in the Mono Lake matter. The council was generally supportive of what LADWP was doing because at that time Ron Deaton was the chief legislative analyst, and he had a solid hold on the council, and he was very much a supporter of LADWP, whatever it was they wanted. There was one dissenter, that was Zev Yaroslavsky at the time, again from the west side. That was his constituency. They were the ones who had the bumper stickers on their car that said, "Save Mono Lake." I have 10 minutes. I probably won't take up all that time. I think as we were looking at the policy issues related to Mono Lake and where the lake level should be set, this issue of the TUFAs, am I saying that correctly? The TUFAs, was really an important determinant, because whatever lake level you set, now that it had these kinds of federal status, you had to preserve some level of the TUFAs being in the lake. That was one of the policy matters that we had to consider. The second was this issues of the land bridges, right? Because when you would go to see Mono Lake, everyone would say, well, if we bring the lake down level too low, then the foxes will go across the land bridges and they'll eat the eggs, they'll eat the birds, and that will be a detriment to the environment. So we had to find a lake level that covered up the land bridges, but it didn't cover up the TUFAs too much, so that you could still have that visual scenic component to it. Eventually, there was I think it was 6971, 6392, thank you, Martha, was the lake level that was decided on. And I think one of the components about this that made the city of LA be able to accept it was that their action was a non-action, right? And that's what I mean when I say water follows the path of least resistance. The actual having to not, it was a non-action. They didn't file an appeal. They didn't go to court. What was it that we had accomplished in all of our meetings, in all of our time together? We had built a level of trust among the mayor's office, among the folks from Save Mono Lake, reluctantly, Jerry Giwi at DWP as well. But we had come to the point where what we wanted the city to do was not take an action. Now, for those of you working in this in the future, particularly you're doing groundwater issues or water conservation issues involving different agencies, for example, that non-action can be very important to a successful conclusion in the future. There's one other component about this I want to talk about, and that is there was a financial element to this deal as well, and that goes back to the market forces and economics. Save Mono Lake, the Mono Lake Committee, had come forward with a proposal in which they would bring state grant dollars and federal grant dollars to do recycled water projects and bring recycled water into the city of Los Angeles. So that the argument that the Save Mono Lake Committee was, okay, you're going to give up 22,000 acre feet of water over here at Mono Lake, but you're going to get 22,000 acre feet of water over here, which is recycled from West Bay Municipal Water District. And so now there was some benefit to my naivete about water issues at that time, because I really didn't understand the difference between potable water and recycled water. Now, today I would never have made that mistake, but that was an important component. We're going to trade potable water for recycled water. The money would come from the state and federal government to do the large recycled water plant at West Bay Municipal, which then could use the water for LADWP. Now, the money and economics were an important component because it allowed us to tell the story within City Hall. This is your governance issues, right? It allowed us to tell the story within City Hall of why we were doing the settlement and why the settlement was a good idea. Because we're going to trade this much potable water for this much recycled water. We're not going to have to pay for the recycled water project. That's going to come through grants and loans from the states and feds. It was an important component, but it wasn't the driving component. It was important for being able to have a story to tell the governance, the people that were involved in governance. I hope this has been sort of a different view of water policy making and the politics of it all. We were driven in the mayor's office because we wanted to have a relationship with the environmentalist community that we did not have at the beginning of the mayor's administration. And this was really the first step in many things that Mayor Reardon did to reach out to the environmentalist community, and that I played a role in. The other thing was, from our perspective, you couldn't deal with the other issues along the Owens Valley, in the Owens Valley, or along the aqueduct if you didn't deal with the Mono Lake issue first. So you couldn't get to stream restoration or Owens Lake restoration or dust mitigation or all those other things. You had to deal with the first issue first. That, again, comes back to the geography, right? The geology. Where was the water coming from? So, human factors, human dynamics, the politics. Why did it work? I liked working with Martha Davis and Ed Manning. We ended up putting Ed Manning on the Airport Commission, where he represented the West Side, an environmentalist perspective. I liked working with those people. And so that made it possible for me to have the trust and to make the arguments within the administration that this was the right way to go. So the human dynamics, the politics, extremely important. The market forces and economics, the money that was brought to the table to help switch out the potable water for recycled water. Today, we would understand that's not exactly a one-for-one, but at that time, in my mind, it certainly was. The governance structures. It took the LA City Council under the direction of Ron Deaton, and at that time, Bill McCarley, I think, had moved over to be at LADWP, to accept that we were going to accept the decision by the State Water Resources Control Board. So the governance matters are extremely important. And then, of course, the environment. We wanted to do something good for the environment. Mono Lake is a place of special beauty. It's sort of like, and Martha, don't take this the wrong way, but it's sort of like one of those really ugly dogs that's so cute that you can't, it sort of warms your heart, and there's something about that with Mono Lake. You go there, and by the way, those brine flies are really, really annoying. So it's not a place you want to hang out, especially when the flies are in season, right? But we wanted to protect the environment. And then, again, as you're working in water policy, understand the history that went before you. Understand the geology, understand the geography, and understand models are useful, but they're not fact. And with that, I'll conclude. Thank you.
Are there any questions? Let me just broaden that question a bit to the panelists. Where do you think how do you think the concept of public trust might unfold, and how do you think it might unfold differently, or what would it take to make sure it continues living and breathing?
Well, I think it takes, is this on?
Oh,
Oh, do I have? Okay, good. I think it takes continued activism, and you know, the Mono Lake Committee and its allies were enormously important in the whole Mono Lake story. We've just heard, you know, suppose there hadn't been those bumper stickers on the west side. So it takes activists to focus in on particular problems, serious problems, and judicial action is part of the solution. It's not the whole story. People like myself, lawyers, tend to focus on that part, but there's many other parts. I worry, you know, you need a lot of things coming together. Better to be lucky than right. Was that what you said, Mark? But I just, as I said at the end of my remarks earlier, I am concerned that there's not a whole lot going on. Now, one thing that is going on, which is very, very interesting, is the question of groundwater and the public trust doctrine. There's litigation involving the Scott River, which is up in the north, Siskiyou County, that's been going on for several years now. And there is a recent decision from a judge in the Sacramento Superior Court in which he said, first of all, that the public trust doctrine does not apply to groundwater per se. Remember, navigability is still one of the controlling issues here. So he said it doesn't apply directly to the groundwater, but, and this is a very important but, he said where the extraction of groundwater has a significant impact on the navigability of a surface stream, then there can possibly be public trust relief. So to the extent that the pump extraction of groundwater in the Scott Valley significantly impacts the navigability, first of all, you have to establish that there is navigability, but the navigability of the Scott River, then there may, at some future time, after years of litigation, be some relief. I am not quite up to date on that. Last I heard, the defendants were seeking expedited review in the Supreme Court. They had expedited review back in 1983, by the way, in Audubon, and I'm not sure if maybe somebody here knows if they've actually ruled on that request or not. But so that is going on, and that's important. And of course, in jurisdictions like Hawaii that have abandoned the navigability notion, they do apply the public trust doctrine directly to groundwater. But I think, you know, it starts with identifying the critical environmental situations. Where are the problems? There was this major problem in the Mono Basin. There's a major problem potentially on the American River with the flows. There was a problem where I live out by Buda Creek, where in the drought of, I guess it was 76, 77, and later, maybe it was a later drought where they began to have dying fish and so forth. And the Buda Creek Council, a community group, focused on that issue and got some legal help. And that's a critical, this hasn't been mentioned, but having talented legal help is very important in these disputes. The Mono Lake Committee was enormously fortunate in landing Morrison & Forster, a major firm headquartered in San Francisco, to do the work pro bono. That doesn't mean they didn't get paid. It means they got paid much, much later when they collected attorney's fees. But without Morrison & Forster, I don't know how far this whole thing would have gone.
I think I know what you're talking about because I was at the Coastal Commission meeting last week where it was decidedly disappointing, both because it was brutally apparent that members, a large number, if not all, no, there was one that actually read the submissions. The rest of them didn't have a clue. More importantly, perhaps, is this. The Audubon decision recognized concurrent jurisdiction between both the State Water Resources Control Board and the courts. That was a really good thing. Last week, the day after I was in that Coastal Commission hearing, I was in Judge Tom Will's Superior Court room in Monterey County. Who's here from Stanford? There's one. I thought there were. And are you? You have a group of students who are pursuing in the capacity of plaintiff a case called Coastkeeper versus Monterey County Water Resources Agency. Judge Will, full disclosure, Tom Wills and I shared a windowless room 35 years ago as law clerks. Judge Wills decided that he was going to invoke the Audubon decision last Friday. This is literally 72 hours ago. and ordered the case to be referred both to the Central Coast Regional Water Quality Control Board and to the State Water Board because of the conflicts related to water quality issues. This is all about an open agricultural drain where the county doesn't control what runs into it, and where the plaintiffs are alleging that there are public trust resources that are being compromised because of the county's failure to limit agricultural drainage into the drain. And so he notified both parties that he was going to be asking for both the Central Coast Regional Water Quality Control Board and the State Board to address a series of questions that are actually not yet been prepared, and that will be forwarded here in the next, I think they're supposed to have them all done by the 1st of December. That's going to be a huge case because it pits the environment that Felicia was talking about earlier against agricultural interests, and it also puts localized water entities that fall under the jurisdiction of counties, which are divisions of the state of California, in the role of, it asks the question, are divisions of the state subject to and responsible for the enforcement of the public trust doctrine in regards to these open water drains that pick up pollution from other sources? It's a very interesting case. It's not on anybody's radar screen that I know of, and Tom was very, I thought, prudent in terms of invoking the Audubon decision when he did that. Long and short of all of this is, this isn't going to get fixed just by the State Water Resources Control Board, nor is it going to get fixed by Superior Court actions. The recognition in Audubon that there's concurrent jurisdiction allows us, people who live in California, the option to pursue aggressively the preservation as well as the expansion of the public trust doctrine and the protection of public trust resources in both of those forums, and we should do it with vigor.
I just have to add, those are the lawyers' perspectives, right? I would say there's a drought, right? And so when there's a drought and projects like that come before someone like the Coastal Commission, what is their natural impulse going to be? And particularly if whoever is seeking the application, I assume is for some sort of desalination plant, then if the people who have making the application have been able to deal with the entrapment and impingement issues in such a way that the staff may have felt comfortable, then certainly, and I'm not familiar with that particular example in its details, but don't overlook the larger world in which we're living in, which is in California today we have a drought. So the State Water Resources, the Coastal Commission is responding in a certain way to that.
It's just hold on.
No, please,
Yeah.
please.
This issue, this case, is turning on the issue of groundwater rights. The very groundwater rights that were required to be protected pursuant to the 3 statutes that Governor Brown just signed a month ago, and the Coastal Commission's the Coastal Commission completely ignored the issue of the groundwater rights held by private property owners and allowed a private utility that has a history of violations to go ahead and pursue a desalination plant that was that by their own admission was going to impinge on the existing groundwater rights of other private property owners.
I'm not saying it's the right
it's
decision or
it's
wrong
a
decision.
it's
I'm
a
saying
bad
there's a drought
situation.
going on.
Do we have time, Mike, or? Okay, quick, please.
Well, I would say that this is a case where you're dealing with depositional history or depositional geology in essence. And the whole culture of LADWP to that point had been building the LA aqueduct, building the Colorado River aqueduct. They really saw in the water division of LADWP that their mission was to provide water for the city of Los Angeles for the next 10 years, the next 25 years, the next 50 years, the next 100 years. And so I don't see that it was LADWP so much as being flat-footed as it was that was what their culture was, that was what their history was. Their job was to ensure that no matter what happened in the city of Los Angeles, when someone turned on their shower in the morning, there was going to be water that came out of it. Now, I do think that this issue on Mono Lake was an important pivot point for the LADWP, because this is when we began to see them begin to do major water conservation efforts. They began to have much more sensitivity about water use and an understanding of how you could use and substitute recycled water for potable water. And I think you'll see many of the things that came out of LADWP, which today is a national leader in water conservation, right? But I think if you go back to that moment in time, everything which had occurred previously at LADWP was about ensuring that no matter what, LA had enough water.
Thank you. Let me cut it off there. Before we take a break, we have a guest speaker, a bonus speaker. I'll let Mike introduce him, but meanwhile, thank our panel very much.
Thank you all for a lively discussion. In sort of a game of the babushka dolls, where there's one inside the other, I get to introduce the person who will introduce our next speaker. Didi Adamo is a member of the State Water Board. Among many other things, she's the board's policy contact with the Lahontan Regional Water Quality Control Board, whose jurisdiction includes Mono Lake.
Thanks, Michael. I've been referred to a lot of things, but I've never been referred to as a babushka doll. So I really enjoyed this last panel, particularly to hear about the legal history, the development of the public trust doctrine, and the backstory about Mono Lake. So it was a fantastic panel, and thank you all for it. But clearly, we yearn to hear more. There's a piece that's missing here, and that's why it's such a pleasure that I will be able to introduce our very special guest. At this time, I'm honored to introduce Justice Cole Blease, who has a very special role in the development of the public trust doctrine. His decisions in Caltrout 1 and Caltrout 2 brought the State Water Board around to tackling the Mono Lake issues and are the direct cause, as we've heard, to D 1631. Justice Blease has served as an Associate Justice of the Court of Appeal, 3rd Appellate District, since he was appointed by Governor Brown in 1979. He's authored more than 3,000 opinions on a broad array of subjects, several hundred of which have been published, including a dozen on water law. He's been an annual participant in Dividing the Waters, a national conference for water masters and judges on water law matters. We're honored to have him join us today. Please join me in welcoming Justice Blease.
Thank you very much. There's an old saw that whiskey's for drinking and water's for fighting. And that leads me into some talks about fighting. It's been my experience that a few good court orders are a real stimulant to action. Is that on? Oh, I got to be closer. It's going to be down my throat. Okay. All right. As already been mentioned, these two cases that I had the pleasure of authoring were a stimulant to action. The beginning of all of this is with two statutes that were passed, one in 1937, one in 1953, the first of which is Fish and Game Code, Section 2937, 5937, which has a very simple line put right down in the middle of it. It says there shall be water released from dams to take care of the fish below the dam. 5936, which was passed in 1953, sought to implement that with respect to Mono Lake area, and did so by, in effect, requiring that with respect to all permits and licenses that were issued should contain a section which complied with section 5937. The problem was that those two statutes were passed, one in 1937, one in 1953. There was no implementing legislation at all from the Water Board until the middle of the 1970s. And from what I understand, it took another few years to get more action with respect to the regulations now pending. And that leads to the reasons why this is, I think the reasons were quite obvious why this happened. Without this litigation, nothing would have occurred. And as a matter of fact, there was an enormous resistance to these decisions and others which I wrote dealing with the Owens Valley, all as a result of the aqueduct. One of the important things to understand about the development of these cases is that at the time that the initial so-called water permits were obtained, they did not have the ability to convey all that water to Los Angeles. That did not happen until the building of the second aqueduct in 1970. So as a result of that, what happened was that the permits, in effect, were attempting to cold storage water for future use in LA. And therefore, the permits were essentially worthless. I didn't discover this, the actual permits, until after we had put out an opinion. Then I read the LA Daily Journal comments by the lawyers from the LA Department of Water and Power who pointed that out. So we just granted a rehearing, took the permits, and we read them all. As far as I could tell, there was not a valid permit in the bunch, because all of them depended upon the completion of the second aqueduct. They did not have the capacity for at least 50,000 acre-feet of water to deliver to LA until that occurred. So I might point out that there were two opinions. The first one has to do with the substantive issues of the entitlement of the rights that were given pursuant to these statutes. The second one had to do with the enforcement order, which I think is a reflection more important than the substantive opinion, because nothing was going to happen until we ordered something to happen. So let me talk about the substance of the matter. It would seem a simple matter to take a single sentence that says you have to release enough water to take care of the fish below and release it. And the water lawyers came in and said, oh, no, it's not that easy. And I said, there's something complicated about this with this language. And they said, oh, yes, we'll have to explain that to you. Well, then you can explain to me what water is, what release is, what a dam is, what fish are. And when you get through with that, will you tell me there's anything complicated about this? So the whole case, in a sense, was a question of why we shouldn't get there, why we shouldn't enforce the statute. And that led through a lot of ins and outs, including statutes of limitation and the like, and the power of the Water Board, the various water statutes and water rights that bore on these questions. The one substantive matter I might want to mention that bears on the public trust doctrine is that there is a public trust section in that statute, in that opinion. That arose, as I've talked with Jan Stevens over time, quite by accident. It arose because one of the issues that was raised was a question of the statute of limitations. Because the litigation was not commenced till the 1980s, dealing with this, with permits that supposedly occurred long before that, and some years after the second barrel of the aqueduct was completed, why was the statute of limitations not run? And so that the question really raised an ancillary question about the public trust doctrine, because there's an old rule that you cannot apply the statute of limitations where there's a public trust involved, especially when you're looking for the future. In that case, as we said rather a lot about the public trust doctrine, including the fact that the public trust doctrine has developed in a significant way and no longer is confined simply to navigable waters, as Audubon made clear, and as I think our opinion made clear as well. And it applied in the context of the use of the water for the fish in the streams below the dam. Now, there's a lot of caveats to this, and part of the caveats are the ones that have been mentioned politically, because you cannot consider any of these cases without the fact that it's going to be an enormous political reaction, especially in times of a drought. So our opinion is full of those as well. So it was not the end all of the be all and end all of the public trust doctrine. Public trust doctrine, in this sense, is a curious doctrine. It stems from a common law doctrine in Europe. It's no longer just a common law doctrine. In fact, you could almost say it's a statutory doctrine. It certainly was in the case of 5937 and 5926, that those statutes are seen as an embodiment of the public trust doctrine. Our constitutional revision of 1872 made it very clear that there's a strong connection between the common law and statutory systems. In fact, in some sense, our 1872 statutes were a codification of certain aspects of the common law, and also carried with it certain authority on the part of the courts to fashion new common law. So I visualize it in the future, the public trust doctrine, such as it will become some amalgam of statutes, of constitutional policies, and of court-made policies. There's a wonderful old article by Justice Traynor called Statutes Revolving in Common Law Orbits, which talks about the interrelationship between the common law and statutes. And where statutes are ambiguous, where statutes are vague, there is an opening for the introduction of common law. Now, there's nothing vague about the statutes that were involved with Mono Lake, and so this leads me to the discussion of the enforcement thing, because the important point to make is that the Water Board did absolutely nothing about these statutes for 30 or 40 years. In fact, the regulation that was regulation initially adopted was a result of our order that they be done. You are now directed to put these restrictions in the permits for LA Department of Water and Power. We had a little difficulty at the beginning because the trial judge did not want to do that right off the bat. So we got it back and said, there is a hurry here. Do it now. And that opinion, which is a fairly strong opinion about carrying this out, I think is probably more important than the substantive matter. So it happened. So with respect to the question about what lawyers or courts do, I could make the observation that a few good orders will create a lot of action, political and otherwise. Without that, thank you.
Justice Blease, thank you. So we all know that one of the best parts of any conference is the breaks, so I encourage you to ambush our speakers and continue the discussions we've started. Nonetheless, we will reconvene and begin again at 10:50 Steve Jobs time.
Thank you.